Every day in the USA, people find themselves in court.
These matters are in the District Court of Greenwood County, Kansas. Cases entitled State of Kansas versus Gina and Louise DiMercurio Perez. They are case numbers 2023 CR 209, 2023 CR 215. Richard Paw appears as defense counsel. The defendant appears from the jail's Zoom location in Greenwood County. Jill Gillette now appears for the Greenwood County Attorney's Office in the state of Kansas. This court's understanding that these matters currently come before the court for arraignment. Is that correct, counsel?
Yes, Your Honor.
Correct.
Does your client desire the charging documents to be read to her, Mr. Paw?
No, Your Honor. Ms. Perez would acknowledge copy and receipt of the complaint, waive its formal reading, and pursuant to plea negotiations, she'll plead no contest in case 23 CR 215 to an amended level 3 distribution of oxycodone. And then count 2, trafficking and contraband, a level 6 felony. Pursuant to plea negotiations, upon successful plea, the state will dismiss 23 CR 209 in its entirety.
All right, Ms. Gillette, is that?
It's correct, Your Honor. That's correct, Your Honor.
All right, Ms. DiMercurio, there's been an announcement made that you would now resolve these cases apparently by entering no contest pleas to the amended count 1 in the 215 case to a level 3 drug felony and a level 6 non-drug felony. And then the other case would be dismissed. Is that indeed your intention?
Yes.
All right, I've got a number of questions I'm going to need to ask you regarding the taking of a plea of no contest. If there is anything that you don't understand, I'll give you the opportunity to confer more with your attorney, Mr. Paw, privately before we go any further. Just let the court know if you need that time to confer and get further advice, okay?
Okay.
State your full legal name for the record.
Gina Louise Perez DiMercurio.
How old are you right now?
39.
What's the highest level of education that you've attained?
11th grade.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No.
Have you ever been adjudged to be mentally ill?
No.
Are you currently under the influence of alcohol or any drug?
Absolutely not.
Are you currently taking any type of prescription medication?
No.
Are you supposed to be taking any mental health meds that you are not currently getting?
No.
So as you participate today, do you believe your mind is clear and that you have a full understanding of what's going on in court?
Yes, sir.
Did you receive a copy of the original charging document in this 215 case?
I did.
Do you understand the nature of unlawful distribution of a controlled substance charged as a level 3 crime?
Yes.
And do you understand the nature of the charge in count 2, trafficking in contraband in a correctional facility?
I do.
You understand that when you enter a plea of no contest, you are not admitting that you did these things, but nevertheless, you're also not contesting that you be convicted of these offenses just the same. Do you understand that? I'm sorry, I didn't hear the response.
Yeah, I understand that.
Okay. You further understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to those charges.
Yes.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Paw, and that you can present evidence on your own behalf of the trial and subpoena your own witnesses to court?
Yes.
Do you also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to get up on the witness stand under oath and tell your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described.
Yes.
Are you also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes.
You understand that when you enter a plea of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yeah.
Do you further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes.
Are you aware of the possible sentence that could be imposed as a result of this no contest plea that you're attempting to make?
Yes.
Let's go over that. On the drug grid under the Kansas Sentencing Guidelines Act on level 3, in the most favorable criminal history category of I, you could receive as little as a 46-month sentence. In the worst criminal history category of A, you could receive up to an 83-month sentence. So the sentencing range is 46 to 83 months in prison, depending on your criminal history. As you said today, we do not know with certainty what your criminal history is. You better than anyone else here ought to know what your criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of their research as of date of sentencing, that will determine where you fall along the level 3 drug line, and you'll be sentenced accordingly. Do you understand that?
Yes.
Ms. DiMercurio Perez, do you understand that that entire line is presumptive prison under the law?
Yes, I do.
Okay. On the non-drug offense, the level 6, in the most favorable criminal history category of I, you could receive as little as a 17-month sentence. In the worst criminal history category of A, you could receive up to a 46-month sentence. So the sentencing range on a non-drug level 6 is 17 to 46 months. Do you understand that?
Yes.
You also understand that you could receive up to a $100,000 fine for that particular offense. You understand that?
Yeah.
You also understand that on the severity level 3 drug crime, you could receive up to a $300,000 fine.
Yeah.
In addition to any fines, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes.
Are you aware that post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances?
Yes.
You also understand that if there are any special sentencing rules that apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence. Do you understand that?
Yes.
Do you understand the difference between consecutive and concurrent sentences?
Yes.
Consecutive sentences are boxcarred back to back. That would usually result in a longer overall sentence. Concurrent sentences means that they run together. When you're serving one, you're serving the other, which obviously would result in a shorter sentence. Do you understand the differences?
Yeah, I think so.
Okay. Now, did you have an ample opportunity to discuss legal matters like that with your attorney, Mr. Paul, before proceeding here today?
Yes.
You want any more time with Mr. Paul privately before we go any further?
No, I'm okay.
Are you satisfied with Richard Paul's services and advice as your attorney?
Yes.
Now, this plea agreement that you've reached, you understand that if there are any plea agreements regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but would not be bound by that. You understand that?
I do.
Has your no contest pleas been based upon any threat or promises as to what the court will do in regards to your sentence or any other type of threat or promise?
No.
So let me ask you formally, how do you plead to amended level 3 drug unlawful distribution of a controlled substance as alleged in the 215 case?
No contest.
And to count 2, traffic in contraband in a correctional facility, a level 6 non-person felony as alleged in count 2.
No contest.
Factual basis for each one of these offenses, Ms. Gillette?
Your Honor, on August 31st of 23 in Greenwood County, the defendant had been arrested on case 23 CR 209. She had a warrant for a prior case that we had that she was placed to come in and do a sanction. And then when she was arrested, there were drugs found within the car, and she was brought into the jail. When she got into the jail, they read the sign out front that tells them that anything past that sign will be considered trafficking contraband. She was within the jail, and on September 3rd of 23, Deputy Lazar was dispatched to the jail. There had been a jail request from the back, notating that Ms. Perez had drugs on her, that she had showed them to others, and they were afraid she was going to give them to other inmates as well as be taking them herself, and that she had 200 of them. A female deputy was summoned, and at first Ms. Perez denied it. She was told she would be taken to the hospital to be x-rayed, and then the drugs would be removed from her. So she gave up the bags of pills. There were 2 bags, one being a balloon type bag and one being a different kind of bag. It was a container. Total, they contained 186 oxycodone pills that had been smuggled into the jail in a body cavity of Ms. Perez, and that there was an intent to share those with other inmates once she was in the jail, but she was also using them and showing them also to other inmates.
So after the amendment, is the charge possession with the intent to distribute?
With the intent to distribute a level 3, Judge. There's a presumption with having 186 dosage units on her person.
All right, Ms. DiMercurio, are you making a plea of no contest and accepting conviction for these 2 offenses freely and knowingly and voluntarily?
Yes, but Judge Ricke, the thing is, they were
Hold
not for
on a
anybody
second.
else. Those
Just-
were for me. Like I
Yeah,
didn't distribute
I'll
it to
talk
nobody.
to, I'll address that, okay?
Okay.
Judge, on the factual basis, Ms. Perez just wants it well known is that at the level that she had, there is the presumption that it was for distribution, but she is she at the time she was a very serious addict, and she claims that those were for her personal consumption. But an inmate in the jail saw him and alerted authorities. So, Judge, we're not disputing the factual basis. Ms. Perez just wanted to clarify with the court.
It's just that she's waived any comment as to factual basis by entering a no contest plea.
Yes,
She's saying she's not contesting what the state is charging. So
we understand that, Judge.
statements are noted, but
Thank you.
all right. So despite your reservations, Ms. DiMercurio, you do intend to enter no contest pleas and accept conviction of the possession with the intent to distribute the oxycodone in amended count 1, and then also trafficking and contraband in a correctional facility in count 2, correct?
Yes.
All right. Noting your statement earlier, Mr. Paul, do you know of any legal reason why the court should not accept your client's pleas?
No, Your Honor.
Mr. Gillette, are you aware of any such legal reason?
No, Your Honor.
All right, Ms. DiMercurio Perez, are you aware of a legal reason or any other good reason why the court should not accept your no contest pleas here today?
No.
The court will accept the no contest pleas and finds that those pleas are made voluntarily. She has an understanding of the nature of her charges and the consequences of her pleas, and a factual basis for the pleas does exist. Court finds the defendant guilty and the judges her therefore convicted of level 3 drug possession of a controlled substance with the intent to distribute, an amended count 1, and then in count 2, traffic and contraband in a correctional facility, a level 6 non-person felony as alleged in count 2 in the 215 case. Pursuant to the court's acceptance of these pleas, the court will dismiss in its entirety case number 23 CR 209, consistent with the plea agreement reached. Court orders a pre-sentence report be completed to accurately determine the defendant's criminal history, and the court will set an appropriate date for sentencing. Ms. DiMercurio, how come you're in custody right now?
My sanction just was up, and I'm still in here.
Okay, so you were doing sanction time in relation to a probation violation?
The last time for my last case.
Judge, it was 23 CR 33 was the case.
Set sentencing in this case for Thursday, March the 14th. I'm contemplating 1:15 p.m., Mr. Paul. That work
March
for you?
14th, 1:15.
Yes,
Yes, that will work, Judge.
very well. Sentencing in this case is set for 1:15 p.m. Thursday, March 14, 2024.
Do I even have a bond?
I can't answer that. I presume that you do. This is this court's first involvement with these two cases. And now we're down to just the one case, the 215 case. Counsel, would you announce for the record your understanding of what her current bond requirement would be in the 215 case? Based on what was earlier set by another judge?
Judge, I don't have a note as to what her bond is on that case. She had 160-day, she had 120-day sanction on her other case. And due to the new conviction, part of the plea agreement is we will be filing a motion to revoke based on the new conviction. And the part of the plea agreement is that they're consecutive, but if she stays in, behaves, doesn't run off, because she's run off twice on us, that we will agree to recommend the new cases counts concurrent. But if she runs off, I'm free to argue as I see fit because of her consistent failures to appear or running off and didn't come and voluntarily serve her sanction. This is the matter where she left the courthouse after she was in the courthouse and sentenced to the 60-day sanction, and she went back home with her family and had left the courthouse, and there was a revocation filed, and she was ordered to 120 days based on failing to come and do her 60 days. She had an additional 60 ordered.
All right, it very well could be that she will not have completed that 120-day sanction time by time of sentencing in this case.
I already have.
She's close or right at it.
Yeah, she's pretty close, Your Honor.
It was the 29th of December.
Well, my assistant has sent me a chat message that relates that she's got a $10,000 cash or professional surety bond requirement in this case. Court's not inclined to alter it. So the bond requirement is still $10,000 cash or professional surety required. Ms. DiMercurio, your lack of good faith in not reporting for your sanction time, which resulted in an even longer sanction period, speaks volumes about your lack of reliability in coming back to court when scheduled to do so. It would seem to the court that the one way that I can assure that things get taken care of on time in this case is to leave you in custody. Nevertheless, you do have a $10,000 cash or professional surety bond requirement in this case. Obviously, I don't know if you have other holds on you from other cases or jurisdictions, but that will remain unchanged at this time. All right, March 14, 1:15 p.m. for sentencing in this case.
And
Anything else we need to address, Ms. Gillette?
I can't think of anything, Judge.
Mr. Paul, anything further at this time?
no, Your Honor, but I would like a breakout room with the jail, please.
I think we can accommodate that.
Thank you, Your Honor.
We'll go ahead and stop recording.
She was told she would be taken to the hospital to be x-rayed. The drugs would be removed from her. Total, they contained 186 oxycodone pills that had been smuggled into the jail in a body cavity of Ms. Perez.